Hi, I'm Kim Rathbone with Rathbone Group and on Subrogation, and we're here at the National Association of Subrogation Professionals annual conference in Orlando, Florida. I'm joined here by Steve Kraus and Noah Gradofsky. They are New York and New Jersey attorneys with the law offices of Jan Meyer and Associates. Thanks for joining.
Thanks for inviting us.
Happy to be here.
And I understand you have particular experience with rideshare in your no-fault states. Can you tell me why that's special?
Yes. So there is a new way, as we all know, that people move from place to place rather than using their own car or using a taxi or a limo. And those are organizations like Uber or Lyft. So the states have been trying to figure out how to regulate those ride-sharing companies. And we now have legislation which by which the states have imposed insurance requirements on those companies. And in New Jersey, what they have done is they have required the ride-sharing companies to provide the same amount of liability insurance as we used to require for limousines. So we provide $1.5 million of coverage when the ride-sharing driver has a fare with him or her. And then the ride-sharing company also has to provide a limited amount of medical pay coverage for the drivers. When the drivers are just searching for a ride, but when they are logged into the system but have not yet picked up a fare, then they have to provide a much smaller amount of coverage. Mm-hmm. So the question is whether or not you can be, if one of those vehicles causes an accident, and whether the company that pays PIP benefits for the person injured can be reimbursed from the insurance carrier for the ride-sharing company. And essentially what the statute provides is that reimbursement is available in those situations.
Mm-hmm. Yeah, so you're trying to find the exceptions and get the money in as a result.
Well, we're actually trying to find those situations in the exception would be
to the no-fault rules.
Yes.
Yeah, the exceptions to the no-fault rule. So these people who are operating these vehicles with ride-sharing companies are not required in New Jersey to maintain PIP coverage, which means that they are subject to claims for PIP reimbursement.
While they are having a customer in their car, interestingly, when they don't have a customer in their car, when they have a customer in their car, then they are not required to have New Jersey PIP. So they're not part of the no-fault system, and you can go after them. Mm-hmm. But if they're even connected to the network, but they don't have a fare in their car, they still require PIP, and therefore you probably can't go after them. So it's a very subtle distinction.
Yeah, and what makes this an issue is that most people who are driving for a transportation network company are just driving what looks like a private passenger vehicle. It's not a yellow cab. It's not a black vehicle. They're just cars. So if you were just to look at the car or look at the description on the police report, you would think that PIP reimbursement was not available. But once you are able to determine that they're driving for a ride-sharing company, then the statute kicks in and they are subject to the PIP reimbursement claim.
It begs this question of this new type of vehicle that is sometimes a taxi, sometimes not a taxi, and I think across many different no-fault states it's going to be very interesting to see how they apply their PIP reimbursement statutes to that. So for instance, in New York, you're allowed to make a recovery when a vehicle involved in the accident is used principally to transport people for hire, as a taxi. So it will be very interesting to see how New York interprets that when you're talking about someone who uses their car 5 days a week to go to their regular work, and then on Sunday uses it as an Uber. Stephen and I both think probably the court would say anytime it's being used as an Uber, it would be counted as being for hire. But it really will take a lot of case law to determine exactly how this will be interpreted. So I'd recommend for any different state they may find laws that express, for instance, in New York and New Jersey, when these vehicles require to be part of the no-fault system, but they haven't caught up in the statutes as far as the reimbursement, so there might be issues of how to interpret that. And I think those are very interesting questions to examine.
Yeah, and we think that the answer would be that in New York that these vehicles are subject to the loss transfer, because the question will be whether or not Uber always uses the vehicles as vehicles for hire, and of course that's all that they do. So we won't be concentrating on what the owner of the vehicle generally uses, what their general use of the vehicle is, but what Uber or Lyft's use of the vehicle is.
And do you have any good advice, quickly?
So I think very, very quickly that looking into a file, you really have to ask questions of your passenger of any statements that you're getting. Were you in an Uber? Was the other vehicle? Do you know if it was an Uber? Because it won't be readily apparent, and then you have to find that out and figure out if that gives you an avenue for recovery.
I think that's great. Thank you for joining us, both of you.
Thank you
for inviting us.
I'm Kim Rathbone for On Subrogation. That's the long and short of it.